And call the member for Banks.
Well, thank you, Deputy Speaker, and it's very good to have the opportunity to speak on this very important topic of intellectual property, and specifically the amendment laws that are before us this evening. And of course, Deputy Speaker, intellectual property is one of the bedrocks of a market economy, because in the absence of robust intellectual property laws, people will be very reluctant to invest. The protection of one's unique ideas is really fundamental to our economic system, and that's why we have a important intellectual property regime. It's not necessarily a front page issue, Deputy Speaker, but it is absolutely critical aspect of our economy. Now, there is an important balance that needs to be achieved in the realm of intellectual property, Deputy Speaker, between encouraging innovation and defending innovation, whilst at the same time not making it too difficult for new competitors to enter the same market. So there's always a degree of tension between those two goals, and a number of the initiatives in this amendment bill that we're discussing this evening do address that very point of where that line should be. But it is important, I think, Deputy Speaker, to reflect on the importance of intellectual property in the Australian economy, to think of some of the amazing success stories that we have achieved as a nation that frankly wouldn't have been possible without a strong and orderly system of intellectual property regulation. Now, one of the government's key goals, of course, is a simple and orderly set of structures for business, the removal of unnecessary burdens of red tape, so ably led by the Parliamentary Secretary to the Prime Minister, and it applies in this space of intellectual property as well. But think about a company like Cochlear, Deputy Speaker, an extraordinary Australian success story, employing about 3,000 people, $4 billion of value, of course, for its quite revolutionary ear implants and related technologies. It wouldn't be possible to build a company like that without a strong system of intellectual property and the patent laws that are related to that. So it's very important as a nation, Deputy Speaker, that we have in place laws that encourage the next Cochlear to come along, because we want to be a nation of innovators, Deputy Speaker. And it's interesting and notable that in many companies that rely upon intellectual property tend to have high quality, high paying, high skilled jobs. And those are the jobs of the future, and those are the jobs that we need in this nation. Now, there are many other examples of great Australian companies that have benefited from intellectual property development, Deputy Speaker. Radiata, of course, through the CSIRO, developed wireless LAN technology many years ago, and has generated very substantial revenues through the various settlements related to that important development. And then we've got other great examples like ResMed. ResMed is a world leader, Deputy Speaker, in products related to sleep apnea. And this is an enormous company, Deputy Speaker, that has innovated extraordinarily, has world-leading patents, employs more than 4,000 people around the world, and has a market value of more than $8 billion, Deputy Speaker, and none of that would be possible without a robust system of intellectual property. And it doesn't have to be at that very big picture level either, Deputy Speaker. Right throughout our economy, the intellectual property system is at work. Just recently, the Prime Minister and I visited a business called Ace Gutters in Mortdale, in my electorate of Banks, and Ace Gutters is a fantastic Australian manufacturer and supplier of guttering and other plumbing products, and Ace Gutters benefits from our IP system as well, because they have trademarks around their brands and their various processes that are so important to that fantastic business. And the trademarks regime is extraordinarily important as well, of course, in industries like media, Having come from that world myself, Deputy Speaker, I can tell you that immense value is placed on the protection of the value in trademarks in things like magazines, like the Australian Women's Weekly and many, many others that rely enormously on the IP system. And then we have the world of copyright, Deputy Speaker, and again, it is only the intellectual property regime that protects the unique ideas of creators. And the next great Australian film, whether it's the next Gallipoli or Shine or Red Dog or whatever it is, will again rely on the robust system of intellectual property that we have in this nation. So we have to be careful when we make amendments to the intellectual property system, because the last thing we ever want to do, of course, is discourage innovation in this space. What we want to do is give Australian innovators every opportunity to put their best foot forward, knowing that if they do have unique intellectual property, that it will be defended by our system. And another thing that we've got to do in this space, Deputy Speaker, is make it frankly easier for people to navigate through the world of intellectual property exploitation. Now, this is a somewhat arcane area of law, Deputy Speaker. I would hazard a guess to say there would be no more than a small number of a few thousand people in Australia that would have a detailed understanding of all of the various ins and outs of IP, and it is a very complex area. And as someone who's been involved in applications for patents over the years, and especially the area of business method patents, which is of course a very important area for many businesses, it's not easy. It's not easy to navigate through the IP system, and that's why the change in this bill of having a one-stop shop for the application process for patents in Australia and New Zealand is such a great reform. Because of course, Deputy Speaker, if you want IP protection in Australia, you probably want it in New Zealand as well. And there are no shortage of forms to fill out in this space, and no shortage of documents to be lodged. And if you can do one for two countries, so much the better. So much the better, and so consistent with the government's agenda of eliminating red tape wherever we can in the economy. So now, if you are an Australian innovator and you successfully go through that patent process, you are defended not only in Australia but in New Zealand as well. And we're always working as a government, Deputy Speaker, to increase international cooperation in this space. The fact is that people who are applying for patents do have to fill out many different applications for different jurisdictions around the world. There has been a trend in recent decades towards trying to simplify that as much as possible. There's always more that can be done, and we're certainly committed to working with business and the broader community to help make that happen. The changes in relation to the TRIPS scheme, which are a part of this bill, are also very important, and this is really gets to the heart of the balancing act that you have in intellectual property law, because, as I said before, Deputy Speaker, we must protect the innovators who have done the hard yards and created this intellectual property, but we need to be cautious that in so doing we don't disadvantage members of the broader community. And what the TRIPS changes that are contained in this amendment do is enable generic manufacturers of drugs to apply for a compulsory licence to be able to manufacture those drugs and provide them to developing nations. And of course, we absolutely would all support the very noble sentiment that underlies that policy change. But it is important. It is important that those who have manufactured drugs and have created those inventions in the first place are not cut out entirely of the process of monetising those drugs. And the reason that it's important, frankly, Deputy Speaker, is if there isn't a sufficient commercial return in the creation of new drug types and new drug categories, less people will do it. Less people will do it. And if less people, less companies seek to innovate and create the groundbreaking drugs that we need to address the many horrendous diseases that we face as a community, then a reduction in innovation can be of no benefit to the people who need help. So that's the balance that needs to be achieved, Deputy Speaker. There needs to be a commercial reason for companies to seek to develop innovative drugs, and that's why it's very important that as part of this TRIPS reform process that the original IP owner is compensated when the generic manufacturer provides those drugs to developing countries. Now, we all want, of course, life-saving drugs to be provided to developing countries. It's appropriate that this bill provides for that to be done as cheaply as possible. It's also appropriate and it's also important that the bill provides that the IP owner is compensated, because, as I said, the last thing we would ever want to do, no matter how noble the sentiment, is create a situation where pharmaceutical companies cease to innovate, because we do need the innovation that they produce. Another important change in the bill here, Deputy Speaker, is around the whole world of plant breeders' rights. And of course, the plant breeders' regime in Australian IP law is relatively new, Deputy Speaker. Only was recognised as a specific class of intellectual property since 1994. Prior to that was sort of jumbled up in various other categories. But the issue that we face at the moment, and this is another compliance red tape issue, in fact, Deputy Speaker, and again very consistent with the agenda of simplifying things for Australian businesses. Rather than a plant breeder who feels that their rights have been infringed having to go to the full federal court, and you can imagine, Deputy Speaker, the costs that are attendant in such a process, now possible to go to the Federal Circuit Court. Much simpler, a little bit less pomp and ceremony, Deputy Speaker, and a much quicker, more cost-effective process for plant breeders. And that's a really important reform, Deputy Speaker, and very consistent with the other reform in the bill in relation to the consistent approach in Australia and New Zealand. So, Deputy Speaker, this is a very important piece of legislation. Intellectual property, as I said at the outset, is not necessarily a top-of-mind issue for the majority of Australians, but it is an absolute bedrock of our system. It helps businesses at the local level, businesses like Ace Gutters in my electorate in Mortdale, businesses that are innovating, and importantly it helps businesses that are going the extra yard to create new intellectual property that leads to new innovation. Those are the businesses, as I said before, Deputy Speaker, which will tend to have the higher growth capacity. They will tend to be in higher growth sectors of the economy, and it's very important there's a sensible regime to enable them to compete. So these three important changes in the TRIPS space, Deputy Speaker, in the Australia-New Zealand application process and in the protection of plant breeders' rights and allowing them access to the cheaper legal remedies through the Federal Circuit Court are all really important changes, and I certainly commend the bill to the House.
I thank the member for Bass.